Ortiz. Oops. Excuse me a moment. We don't seem to have mics.
Josh, it's on.
Testing. There we go. Sorry. Colin.
What's your house?
Castanis. Cox.
Present.
Pratt.
Here.
Ortiz. Here. Yee.
Here.
Toby Johnson.
Here.
We have a quorum.
Okay. I asked the members to assemble today to participate in a special meeting because of some general concerns that were expressed to me by our administrative officer and the counsel to the commission, both of whom stated that they needed a decision or a recommendation as to how to proceed with the problems they see as infecting the general subscriber group at a limited level who subscribe to cable services in Sacramento from Sacramento Cable. In their general outline to me, it seemed that it could potentially be a matter of financial impact to members of the subscribing public, and for that reason I suggested that we have this meeting, called the other members to the meeting so that Mr. Spasto and Mr. Blair could outline to you in whatever detail is needed the general problems as they see them, and then allow you to respond as to whether or not you felt action was needed or whether or not it was a matter that could be corrected by working cooperatively with the Sacramento Cable staff and Mr. Ruker.
Mr. Chairman, members, good afternoon. Several issues to take in order today. One is that we've had a resignation of one of our members, and I've asked Commissioner Counsel Blair to update us on what constitutes a quorum now under this change. Brent would address that and put it on the record. That would be appreciated.
In the briefest possible way, after an examination of our governing documents, it's our opinion that we now have 7 members on this commission, and accordingly a quorum is 4 and action must be taken by 4. Heretofore we've had, for the most part, 8, and I don't think we've ever had a full complement of 9, but we are back in a situation now where we have 7 members because Supervisor Muriel Johnson has declined to serve and Supervisor Grantland Johnson has resigned. So at that point, 4 is our quorum. We obviously have 6 and 4 to take action.
There's no provision for an alternate in the event that the Board of Supervisors wanted to appoint alternates for either or both of those people?
Yes, there is, as a matter of fact, and that's exactly what our ordinance provides, is that the board, acting as a body, may appoint persons to serve in their stead.
So that'd be a matter of decision for the board?
For the board, that's right.
And come back to you with their recommendation.
Well, it's not a recommendation, it's actually final action. If they appoint 2 people, then our membership goes up.
Okay.
Well, Mr. Chair?
Look at that, yes.
I have what,
Mr. Yee.
Is the option available for the person who cannot attend to appoint his or her own proxy?
There is
alternate.
Yes, there is such a provision spelled out in our ordinance. That would be a different situation for the city representatives, because traditionally the city has appointed an alternate to the members, but specifically the Board of Supervisors members have the ability, and some of them have in the past exercised that ability to appoint representatives. However, in a situation such as Supervisor Muriel Johnson is a stockholder in one of the partners of our initial franchisee, so it really does not shield her from the conflict by appointing a designee. So the alternative procedure is the one that Supervisor Johnson has just been addressing, which is the board acting as a whole, appointing an alternate, much as the city council has done.
When you refer to board, you're talking about a board of supervisors?
That is correct.
Okay.
Okay. Any other questions to ask? All right. We will accept your advice and take it up as a matter of business at the Board of Supervisors for the two people that are no longer participants in the board or the commission.
Mr. Chairman, members, today's hearing is essentially the second phase of enforcement proceedings within your customer service and rate regulations. The first phase is an informal one where we try to resolve and work out issues at an informal staff level. At staff's discretion, your executive director can bring the matter to the commission for review. And there's two alternatives in that phase. One is, and then it's the one recommended today, is that the commission hear evidence and make a determination of probable cause, and then decide from there how to proceed, whether to seat itself as an enforcement body or whether to refer to a hearing officer, which is recommended today. In another alternative process within your customer service regulations, staff can make the probable cause determination, and then the commission becomes the hearing entity at that time. We're using the middle process today on an issue of the cable company charging for services not provided to subscribers. Because this is an enforcement proceeding and the necessary process and protocol to be followed, I'm going to ask Brent to lead the process and provide options to you and take it from there.
All right. Mr. Chairman and members, to briefly, in case you got lost in that, there are two ways. Our process begins with a probable cause determination, either by the director or by the commission. In this instance, the director has declined to do that and has put that before you. Once that probable cause determination is made, there are two ways to proceed. These are all procedures, by the way, that were negotiated with the franchisee a couple of years ago before they were enacted. The two ways to proceed once the determination is made is either by an evidentiary hearing before the commission, and we scheduled one of those a couple of years ago, or by referral to a hearing officer with a report of the hearing officer back to the commission. At the time we scheduled the last one, the commission expressed concern collectively at the amount of time that would be consumed in hearing the witnesses, because our procedure does allow for the presentation of evidence under oath and cross-examination and so forth. So these hearings are likely to get rather extended. So what is happening here today is that the director has put the probable cause, the first step determination, before you, and if you find probable cause, you have two ways to go. You can either bring it back to yourself for an enforcement hearing as the whole commission and hear the evidence yourself, or you can refer it to a hearing officer. Of course, the third alternative is available to you. You could find that there's insufficient evidence to establish probable cause. The first step has already been accomplished. Before any matter comes to you under any of these, we're committed to an informal effort at resolution under Section 801 of your regulation. That was the first step. That effort was undertaken after notice. That notice was given on October 7, 1993, and that informal effort was held with a conference call in which your director participated. I was a party to that. Mr. Ruckert and several of his associates via speakerphone, and his attorney, Mr. Fudge, who I believe is in the audience today as well. We were all party to that conversation on October 22nd, and at that time, 21st, and at that time we were unable to resolve the matter. At that time, the company's representative, Mr. Ruckert, indicated that he would not comply with the credit requirements of your regulations, and that the removal of the traps would be delayed by an additional 3 months. That was subsequently followed by a letter which I presume you have received, dated with that date, October 21, 1993. On October 22, 1993, we notified formally all of the entities who comprise our initial franchisee, the parent company, its subsidiary, the local company, and the partnership of the local company and the subsidiary, which we know is Sacramento Cable Television, of this hearing, and we are here for that purpose. The definition of probable cause under law is as follows. Probable cause is such a state of facts as would lead a person of ordinary caution or prudence to believe or conscientiously entertain a strong suspicion of the truth of the allegations. Now, this is the definition of probable cause that has been applied by the California Supreme Court, first formulated in 1944 and ratified in several decisions, the most recent of which was in 1992 by that court. So that's the test you would be applying today under these regulations. The evidence you receive is not subject to the rules of the evidence code, and in fact has been primarily presented to you by report of your director, and we will not, in the interest of time, regurgitate all of that evidence. Let me summarize again for you 4 things that you can do today. You have 4 options. Number 1, after receiving the evidence which we'll present to you, which you have received, and the additional evidence we'll present, you may determine that there's a lack of probable cause and the matter will end. Number 2, you may determine that probable cause exists to believe that your regulations have been violated and refer the matter to the hearing officer. As your directors indicated, that is the recommendation we make to you. In that circumstance, the hearing officer would conduct a hearing, parties would be represented by counsel, witnesses would be sworn, evidence taken, and the hearing officer would then report back to you with the findings of fact and recommendations, and you have several choices. Once you get that, you can again reject it entirely, you can modify it, or you can adopt it. The third thing you can do today, you can determine that probable cause exists and schedule an enforcement hearing, an evidentiary hearing before your commission. Basically do away with the process of using a hearing officer. Now, the only condition on that is that our regulations provide that if the commission seeks a penalty, that is a monetary sanction, not a credit to subscribers, but a monetary sanction payable to the commission that is in excess of $15,000, then the company has a right to the hearing officer. So you would have to determine either, in that circumstance, that you did not wish to seek a penalty in excess of $15,000, or you would have to give the company the right to exercise their option and have it before a hearing officer. Yes.
Question on that issue. So you're saying if the commission were to hold the hearing itself, the evidentiary hearing, we could either have up to $15,000 in penalty that would go to the commission, no more, or if we did have a penalty that was higher than $15,000, we would the company would be granted the hearing officer afterwards if they so desired.
Not afterwards, in lieu of. They would have the option to demand a hearing before a hearing officer. In lieu of that.
I'm concerned. In lieu of?
Not in lieu of the hearing before the commission.
Yeah.
Let me just...
And that's unilateral?
It is unilateral if you seek more than $15,000.
The second point that you made, if we were to go after and have this company give a credit to the customers, then there's none of that.
That is correct.
Okay.
And these are not alternative remedies, they're in addition to. But the option in the company for the hearing officer arises only if a monetary sanction is sought which equals or exceeds $15,000.
I have a question too.
Yes, go ahead.
Yes.
My question just relates to the role of the commission vis-a-vis lobbying by the applicant. I mean, by our cable company. One of the things I'm uncomfortable with is I cannot speak for other board members, but I know that through this process I have had numerous requests to my office to come and meet with me on this issue, and I have refused all those meetings, and because I'm not quite clear. We're into what is, to me, a more formal process than lobbying, and so I am extremely uncomfortable with meeting with the company, and I don't know whether you, as our attorney, wants to recommend some or give us some advice on what to do. I'm making an assumption they've been trying to meet with everyone, or maybe have already met with them, and I'd like to, put that issue on the table as to what we should be doing during this time.
We do not have any rules. Well, let me start back. This is a quasi-judicial proceeding under law. That is, you're a legislative body acting in a judicial manner, and in that sense, it's a little bit different than most of the other things that you do where you act strictly as a legislative body. We do not have any rules regarding lobbying of the members of the commission pending a quasi-judicial hearing. Many bodies, like the Public Utilities Commission, do have such rules that prohibit that within a specified period and while a pending quasi-judicial proceeding is pending. We do not have those rules, so there is nothing in law or regulation that would preclude the members from meeting with the subject of the hearing if they wish to do so. If you wish such rules, we could craft them rather quickly from other bodies who have them, but we don't have them.
I think probably, as one member, I think we should have those rules in place. One of the things I'm concerned about that could be happening during this process, but, I've refused to meet, but what could be happening is symptomatic of like a letter that I received. The letters attack the regulator, which is Rich, and then we're going to get into a question of, who's attacking whose credibility, and we're going to get into all sorts of things being said to individual members that do not become a part of the public record. And we're going to be into a quasi-judicial hearing, and we've also got a responsibility to consumers of this system, as well as to the company that we are here to make sure treats our consumers fair. And I don't think that I think as one commissioner that we ought to have rules on this when we're into this kind of a regulation or regulatory environment. And I would welcome an opportunity to see those drafted, see what other bodies have, because I think it's important that anything that gets said on the public record if it's going to affect the decision-making of this body.
Are you suggesting then that rather than to proceed forward today that we...
No, we have to do that too. We're going to have to draft the rules, but I would assume that the board members can discuss this issue right now as to whether they want to have meetings away from the public record with the cable company that's involved in these hearings.
I don't think, that this has ever been brought forward before that we've
never been in this kind of a
resolve this
exact situation before either.
Yeah, let's ask Mr. Blair then to advise us as to what the advantages and disadvantages of such rule would be.
The advantage is that you have a clearer record of the evidence received by the parties sitting in a quasi-judicial proceeding. That is to say, you're sitting as judges of the fact under your own regulations, and so you have a clearer record of what it is you receive, because you receive it all in a public hearing where it's capable of monitoring by members of the public. The disadvantage of those rules would be that it would prevent informal approach by the subject of those hearings to share items that they might not want to share or may be precluded for some reason from sharing in a public forum. I suppose that would be the fairest statement of the disadvantage. It's a policy question whether or not you wish to have that. The law does not require it, but certainly allows it.
Are there other members that have given thought to this or had any?
Mr. Chairman?
Yes, go ahead.
I, for one, had a one-hour meeting with a couple of representatives from the cable company. It was a very business-like meeting. They didn't ask me in any way to express an opinion on what they were saying. They came to the meeting, I heard them out, and they left and with a handshake, and that was the end of it. And I, for one, would like the right to look the other the party right in the face and listen to what they have to say about it. I don't know that if you feel that my judgment would be clouded, that's too bad. But I've been in the business of judging people and listening to material probably for the last 30 years, and I'd like to maintain that right.
Okay, that's a good, reasonable statement. Are there others that would like to comment?
Well, yeah.
Deborah? Okay, right after Deborah.
Yeah, actually, I didn't see that there was a conflict in any way to be able to respond to a request to meet with representatives from cable, and I, in fact, did so for about 20 minutes. And I think it's a process that we go through as a quasi-judicial body in hearing appeals on housing matters, and I used that as an analogy, and I thought it was totally appropriate. I felt that in no way will alter my ability to be fair and objective.
I would agree. James? Or Jimmy?
Yeah, Debbie took the words right out of my mouth. I was sitting in the council. I get information from different sides all the time, and I don't think it affects my judgment as to whether it's going to sway me one way or the other. I still have an open mind.
I would. No other comments? I have the same general attitude towards the matter of meeting with people, that I think it helps to enlarge my understanding and knowledge of particular problem situations, and I did meet with a representative of Sacramento Cable. I have no particular expression of influence or the counter of that affecting me negatively on it. And I do this repeatedly. I think most of us in the particular role we have as elected officials are subject to people coming to us and talking over their concerns with government and what it does to, or how it helps or affects their general
I'm posing it in the question of being the regulatory commission.
Yeah,
this is not a legislative matter.
Well, I think that's the important point, and I would add that too, Isla, that this is a quasi-judicial matter as we now have it defined, and I guess again it becomes possibly a little different matter than a purely legislative decision-making responsibility.
Mr. Chairman, I also think it would be operating under the assumptions that I have to this point. I think it would be a very bad situation to now change the rules and say that I shouldn't have spoken to those people. What is that going to accomplish?
No, I'm talking about rules in the future. I recognize
this is all
that.
Future.
All right.
I recognize that at this particular point we had no rules.
Yeah.
I'm asking that when we get into this kind of a situation, perhaps in the future, that when we're in this kind of a role where we have to worry about an administrative hearing officer or hearing a case ourselves, that is very different in my way of thinking than trying to resolve a zoning issue, for instance, where the neighbors come in and the developer comes in and everybody wants to get their viewpoints out, and you can make sure in a public hearing all of that's going to happen. But when you're in a regulatory role, in a quasi-judicial role, I am disturbed by the fact that you could get one set of facts presented in one kind of hearing and perhaps see it entirely differently presented in a different way or questions asked in a different way. I just think that perhaps in the interests of a fair process for everyone, the cable company and the consumers that we represent, that if we get into a regulatory mode, we ought to have some rules and regulations about our individual meetings with the company we're supposed to be regulating on behalf of our constituents who are the consumers.
Yeah, this would likely call for any matter of that particular description being flagged by our attorney if he felt that it were important. Are there other comments from members of the
I would just like to see some proposed rules that,
Chairman,
that others operate under.
Mr. Chairman, this subject doesn't happen to be on today's agenda, and if we want to have a full discussion, I suggest we put it on the next agenda, and let's have a full discussion. I think there's some important issues that have to be looked at. We have a matter before us today which we have the ability to act on. That's precisely what we ought to do, and if this needs to be addressed, we ought to put it on the agenda and have a formal discussion and get some opinions from our attorney and go from there. But it's not a subject of today's agenda.
Yeah, well, I think in light of the way this was brought to me and the fact that there was no recommendation that we do differently than what we've got scheduled here today, that we would go forward with further advice from our attorney unless there's a desire to make a motion to the contrary.
No, it's not on the agenda per se, but it is pertinent to our role as regulators. And so all I'm saying is please put it on a future agenda, have Brent bring back some possible approaches as to what
Okay, well, let me
do.
direct Mr. Esposito then to have this as a part of the agenda for the next
Well, I'm just
regular
wondering,
meeting.
Mr. Chair, on that matter, it doesn't seem that there's even much of a consensus to do that, quite frankly, on the commission. I may be wrong of what I just heard from commissioners, but I don't know that there's that much sentiment for that. I respect Ms. Collins' view on the issue of a regulatory body, but it seems like we've had most everybody on the commission speak against that concept. If there's some, I mean, I guess what I'm saying is, why go through the motions if we're just going through the motions?
Well,
I don't know.
I would differ on that. I think if there is a matter that at times may come up in our future conduct as a commission, that it would be well at least to know the full extent of quasi-judicial hearings that we may be called upon to conduct, as opposed to the normal routine hearings that we have. At least get some information, Josh, and it would be helpful to me. Now, I probably could do that as an individual if you'd rather not have it as an agenda item.
Well, I don't know. I guess it's up to the commission. It's just, to me, it doesn't seem like there's much support for the concept on the commission, and we could always receive that information.
Well,
I would be interested in receiving it. I just don't know if it's something. If there are commissioners who want to move forward with it, and there's a consensus on that, then let's
I guess
move
the
forward.
reason I want to know is why the PUC has that kind of a regulation. Have individual members of the PUC been sued because of meetings outside the hearing process? I would like to know what has been the record and why regulatory bodies and these quasi-judicial type hearings, why there have been so many prohibitions against, I don't know what the legal term is, the contacts. People have been individually sued. I would like to know of them.
Well, why don't you frame a motion, and we'll get an action on it then, because apparently there is a controversy.
You don't think that we could just receive that information?
You really can't make a motion because it's
action
not
on
on
it.
your
No, that's
agenda,
right, it's not
but you
on the
don't need a
agenda.
motion to direct staff.
Okay.
Okay.
Well, I have the authority to direct staff, bring the matter back to us in written language that we can peruse, not as an agenda item, but for the knowledge of anybody that's so interested. Yeah. Okay, back
All right.
to our
Thank you.
matter of the moment.
We had 4 alternatives. I had explained 3. They were determine a lack of probable cause. Second, determine probable cause, refer to a hearing officer for a future report. Third, determine probable cause and schedule an enforcement hearing before the commission with the proviso that Councilmember Panay and I discussed, which is if you seek a penalty of $15,000 or more, the company has the option of the hearing officer in lieu of the hearing before the commission. And then the final alternative would be to schedule it and conduct it immediately. Someone asked if you could do that. The answer is yes, with 2 provisos. Number 1, the same one that would apply to scheduling a future enforcement hearing. But secondly, the company was only noticed of a probable cause hearing here. So an enforcement hearing requires swearing witnesses and taking testimony and so forth, and they would not have had any opportunity or knowledge that that was going to transpire. So we have a due process problem. So I would not recommend doing that today. So I think you realistically have 3 alternatives. No probable cause and hearing officer, probable cause and schedule future hearing for yourself.
Is there not a third alternative or fourth alternative, and that alternative is that this board could direct staff to go back and negotiate?
Yes. I think the problem that you have is that staff has no ability to negate any of your regulations. So if you wanted to do that, we'd need some more parameters.
The question then comes about, if that's the case, why would negotiation begin to begin with?
Well, the purpose, they're not negotiations. Informal resolution is an effort to gain informally compliance with your regulations. Never does staff have the ability to negotiate away your regulations.
I understand that part.
All right. So the purpose of the informal resolution, to make sure that there's no sandbagging, no surprise, that everyone knows before any formal proceedings are begun what the violation is, how it can be remedied, and so forth, not to negotiate.
Mr. Chair?
Yes.
I have a question of Brent. With what little I know about this situation, question I have with regards to what constitutes good faith effort in trying to live within the framework of the regulations? Are you telling us that it's black and white, that they either have conformed or did not conform with the regulations, or is there room for judgment in the amount of activity toward alleviating the problems that constitute not meeting our regulations?
First of all, there is always room for your judgment in waiving or relieving someone of complying with your regulations. It is clear to me, as your lawyer, and I think it's clear to your director, there was a conscious violation by the franchisee in this instance. And I'd like to summarize, my next step would be to summarize that evidence. I know some of you have indicated you've had informal consultations, and we have given it to you in writing, but I know with your busy schedule, it isn't always possible for you to read every letter of every word that is submitted to you in advance. In essence, the problem is this. The company knew well before the middle of this year that it had installed some 20,000, and the company, by the way, I mean all four entities, so there's no confusion here. We're speaking of all four of our initial franchisee entities. The company knew well before the middle of this year it had installed some 20,000 physical traps in the line that precluded the reception of any channels on any set above channel 27. It knew that as a result of the impact of the 1992 Cable Act that it might desire to realign its tiers. It knew, and the evidence, there are two pieces of evidence in addition to to the report that I've laid upon your table, and I'll be referring to the first of those. They're stapled together. The first is a letter signed by Mr. Ruckert dated August 13 of this year and addressed to a Mr. Dan Briggs, Assistant General Manager, KCMY TV in Sacramento. KCMY TV is also known as Channel 29 and is one of the three channels that is outside the range permitted by the physical traps. The company knew, the evidence shows, prior to June that the traps were in place and they would preclude the reception beyond Channel 27. In June 14th, according to Mr. Ruckert's letter, they received notification of KCMY, Channel 29, that they would require must-carry status. Must-carry rules were put in place by the FCC on April 2 of this year, some 2.5 months before. They required not only upon request that a local broadcaster signal be carried, but and that's section 76.57 of those rules, required that they be carried on the channel designation that the local broadcaster had if it was so requested. And this letter evidences the fact that the company knew as of June 14 or thereabouts that Mr. Briggs, on behalf of KCMY, had asserted must carry and would assert the designation. Additionally, your director has learned in a conversation, and by the way, you may consider hearsay testimony in this phase. Mr. Briggs has told your director and me that he met on August 2, 1993, with Mr. Gruber of Sacramento Cable and reiterated that he would accept no other assignment but Channel 29. That date was August 2. This letter is dated August 13. In this letter, Mr. Ruckert recites the legal position of the company. Prior to July 19, the FCC ruled finally finally, in a final sense, on July 19, that there was no question that channels such as Mr. Briggs' channel, which was a home shopping channel, was in fact within the scope of the must-carry requirements. So the evidence shows that not later than August 13, and if you believe the testimony of Mr. Briggs, on August 2, the company was convinced that it would be carrying KCMY at least beyond the range of the physical traps. It knew that it had to carry KCMY on the basic tier, and it had to carry it on Channel 29 federal regulations required. Now that, if you believe Mr. Briggs' testimony, is approximately 60 days prior to the date required to implement the 92 Act. So they had, at that point, about 2 months to remove the 20,000 traps. There were 3 occasions, according to Mr. Ruckert, in the October 21 telephone call, there were 3 occasions subsequent to that time that the company gave disclosures required by your regulations, which are implicitly required to be truthful disclosures, to their subscribers regarding what would be charged for the basic tier and how many channels would be received. The evidence is clear, it appears to me, that knowing the former fact and knowing the latter fact, the company knew that at the time it put out those disclosures that some substantial portion, up to 20,000 of its subscribers, would be charged $10.50 for 27 channels and be able to receive only 24. You will recall that Mr. Ruckert appeared in your meeting from this podium and told you that the company had concluded that its maximum permissible per channel charge was 38.9 cents. Now that submission does not arrive to you, the rate regulation submission does not arrive until November 15, so you haven't seen it yet, but we accept for this purpose, and I say in the letter arguendo, meaning for the purpose of this hearing, that that is truthful. If that is truthful, and the per-channel charge maximum allowed by law, which Mr. Ruckert suggested to you in public session, is 38.9 cents, they could not lawfully charge $10.50 for 24 channels, and they knew it. So the problem comes that they made a conscious choice, in my view, the evidence shows, to purport to deliver 27 channels, knowing that some 20,000 Sacramentans who were subscribers would not receive 3 channels, and yet charge them for 3 channels they knew, because of their own actions, they could not receive. Now, the company at that point had 2 choices. Number one, it could begin removing traps. But if it did so, it knew that the people who were limited basic subscribers, with the system still in its unscrambled state, would be able to receive more channels than what they were paying for. Or they could wait until they had scrambled the system, October 1, and then remove the traps. But they knew that the downside to that approach was that they would be charging people for channels they could not receive until they could get around to remove the traps. The company, in my view, the evidence shows, made a conscious decision. There is other evidence, and when we get to the hearing officer, the hearing before this, we will call Mr. Briggs, and we will have him recite the comments that were made to him. And you can draw inferences as to whether or not there was the degree of the consciousness. But at this point, I'm only suggesting you reason from the alternatives available, that the company chose not to begin taking the traps out, which would allow people to receive more service than they were paying for. Instead, they chose to leave the traps in place and not to begin to remove them, contrary to what Mr. Ruckert says in his letter to you today, not to begin to remove them until after the system was scrambled, so as to prevent that from happening, with the concomitant side effect that people were paying for 3 channels they didn't get. Now, what's the evidence of that? Among other things, the evidence of consciousness, and I believe this is permissible under the law. You may draw inferences from contrary explanations being given. The second piece of evidence before you that has not been in your report is a copy of an article appearing in a national trade publication known as Multi-Channel News. Now, this process began with a notice of an informal hearing put out to the chief executive officer of our parent company, franchisee, on October 7. October 18, the public relations officer of Sacramento Cable is quoted in this trade publication as explaining why the traps had not been removed. And this is the first full paragraph of the second column of that article, and I would respectfully direct your attention to that portion of the article. The article describes Sacramento Cable as Sacramento Cable Vision and refers to the regulatory authorities of the city of Sacramento, but I think you'll discover by reading the context of the article, this is our proceeding. Sacramento Cablevision Community Relations Manager Darby Patterson said the cable company couldn't remove all of the traps immediately because as a consequence of poor record keeping, it doesn't know where they are. But she said installers are removing the traps when they see them and have pulled at least 5,000 so far. Now, this article appeared in the issue of Multi-Channel News, which is a weekly publication, the publication for October 18. So you are certainly permitted to draw the inference at some time prior to that date. But after the preceding issue of October 11, Ms. Patterson gave that explanation for why the traps had not been removed. On the other hand, Mr. Ruckert, 3 days later on October 21st, told your director that in fact since mid-August they had been actively removing the traps, but more importantly, they had an accurate record of every single trap in the system and they knew where they were. That every customer record indicated whether or not that customer had a trap. Now, one of those two explanations has to be true and the other false. In my view, you are privileged to draw an inference from conflicting and false statements of explanations of behavior, which would indicate a consciousness of guilt.
From material taken from a newspaper?
Yes, you may consider that type of evidence. It would be sworn testimony if the hearing officer will hear sworn testimony and we would call the reporter. I have no doubt that Ms. Thompson would say that that was the quote she received. I doubt Ms. Patterson would deny it. I would suggest to you that that evidence, that simple conscious evidence of the knowledge of the existence of the traps and their effect, the choice in terms of the false disclosures, 3 in number, and the false explanations display the conscious choice of the company. When we had our informal discussion, Mr. Ruckert suggested that the company had decided that it would now credit $1.17, which is 38.9 cents per channel times the 3 channels they knew they were not delivering, to the subscribers from whom they'd collected that money. No explanation was offered as to why they collected it in the first instance, since there was no question they knew at all times, since midsummer at the latest, that those individuals would not be receiving the 3 channels. But in any event, he offered to refund the money wrongfully collected at that time, and he's made that offer in writing several times since then. The difficulty is, and the reason that we are recommending that you find probable cause and refer this to the hearing officer, is at the time we enacted these regulations, and they were discussed and negotiated with the cable company at that time in great detail. Their counsel at that time was Mr. Moorhead. And the reason that we set up this crediting mechanism for failure to deliver services is that the amounts were relatively small, always small, in terms of cents per channel or whatever. And the concern was that we needed to erect a system which would give an economic motivation to comply with your regulations. We do not have large fines, nor did this commission seek large fines or penalties under your regulations. You sought instead to create what your former director called a self-effectuating mechanism. That is to say, a series of credits which would automatically come into play, which would give the company an adequate motivation to avoid wrongful behavior with small amounts of money. Here we have a situation where the company clearly intended to take $1.17 it wasn't entitled to, and it knew it wasn't entitled to, from approximately, depending on the numbers, 14 to 20,000 persons in Sacramento. And refunding that money, having taken it, is is simply not an adequate motivation to the company to keep them from doing the same thing again. The question is, why did they do it in the first instance if they knew? The answer is the reason they're giving it back is because your director gave them this notice on October 7, and then the conflicting explanations began. It is my suggestion to you that your regulations are entirely appropriate. Your regulations call for the following. They define an isolated outage as any time 10 or more subscribers within the system have a channel which is out in excess of 4 hours. It gives the company 4 hours to restore that channel. In this instance, it applies because obviously we know many more than 10, some 14,000 at a minimum, were without 3 channels. And your regulations set up a crediting mechanism, not for money to flow to your commission, but for money to flow to the subscribers. That for every 4-hour portion or period or portion thereof, in excess of the first 4-hour period, the subscriber is entitled to 1 day's credit of that month's bill, less taxes. That is to say, he doesn't get a prorated refund of taxes. It certainly mounts up. At the time your director sent the notice, it was approximately, based on 14,000 subscribers, it was approximately $600,000 of credit. And it probably is a little bit more than that because the number was declining gradually and has declined since then. I would suggest to you, by the way, that there's a little subtlety in what even Mr. Ruckert has suggested. He actually suggests refunding only a portion of the ill-gotten monies because he says that if he only gives the credit under his proposal, if in fact the service is out for the entire month, if it's out for 25 days of the month, but comes on the last 5 days by removal of the trap, the party doesn't get the credit. This is absolutely in violation of the federal rate regulations. If Mr. Ruckert was telling the truth in setting the 38.9 cent per channel amount, you cannot collect money for channels you don't deliver. And if that, assuming arguendo, that number is correct, he's charging too much. But in any event, the reason for the credit, the larger credit, is to provide a motivational effect so that we don't have to have continually this kind of hearing. If you can certainly find that this was inadvertent if you accept the protestations of the company now that this matter's become public knowledge. But I think also you have adequate evidence from which to infer a conscious choice made probably in early August to leave those traps in place so as to prevent, quote, theft of service by the limited basic subscribers, and then, in fact, deliver fewer of the channels than what they were paying for after the system had been scrambled. That was the conscious choice. That was the choice that your regulations, in my view, were designed to prevent. You wanted them to decide in the boardroom or in the corporate office before this matter came to you that they would err on the side of their subscribers. The reason you did that, in my view, is because there is no competition and you are supplying the alternative to what any other operator or any other commercial entity would have from competition. But in this instance, it is clear to me, the inference from the evidence, that in fact the contrary decision was made to the detriment of approximately 14,000 by Mr. Ruckert's admission on the 21st of October. There were 14,000. There were, I think he said 15,000 as of October 1st. So in the 3 weeks he took out 1,000. One more comment, and then I've adequately summarized from my perspective the evidence. The question comes, what about the task of removing? Was that really undertaken? Was to build on Mr. Yee's comment, is there a room for deciding good faith? I think you have seen a moving target in that regard too. There was a calculation attached to the October 21st or 22nd letter, 21st letter, with a map on the back, and Mr. Ruckert explained how he was assigning 4 persons to remove traps, and he provided a map with outlines dividing it into 4 areas. Of course, the question comes, if you are really selling something to people that you are not delivering, and you have a number of service representatives who are capable of going, remember, not inside homes, but outside homes and removing these traps, why would you not assign more? And the answer is because you can, it is whatever you discretionarily decide. At the time of our conversation, Mr. Ruckert has sent a letter, which you all received a copy of a few days before, saying he would have them all out by November 30th. At the time of the conversation, he said, well, it will not now be until February 28th. And now today we receive a letter that says something to the effect he's pushing it back toward, it's being pushed back toward November 30th, but there's no commitment being made. The reason for your regulations providing that self-effectuating mechanism is to give Mr. Ruckert the motivation necessary to take those traps out. And my suggestion to you is that $1.17 per sub is not that motivation, particularly when it's already money they've paid. The motivation comes from the credit that he sees mounting. And so I submit to you that you have ample evidence on which to find probable cause if you decide to do so. And if you do so, I would recommend, in part to, because of the concerns Supervisor Collin has raised, I would recommend using the hearing officer. And let me just say one word about that. The hearing officer will give a little more, it must be a lawyer by definition, those are the only requirements. But the reason the company has the option for hearing officer and the reason that we're recommending it here, it would give both sides a chance to fully develop the factual record, to examine witnesses under oath and bring that testimony and the recommendations of the hearing officer back to you. So that if they're we're not asking you to impose any sanctions or impose any credits today, make any final decision, whatever. We're asking merely that you find that there's enough evidence to have this matter inquired into, to allow evidence to be presented under oath and recommendations made back to you so that you can determine whether or not credit should be made to these 14,000 to 20,000 Sacramento subscribers. I would answer any questions.
Okay.
Mr. Blair, I apologize if I missed something, and I'm asking you to repeat it, but the multi-channel news article that you refer to as evidence, who gave this article to the multi-news company?
Well, it's
evidence. Did they investigate the things themselves and do this? Or?
Rachel Thompson is a reporter. I've spoken to her, so I know she exists.
Well, I'm not questioning that. I'm just wondering how this information got into the article.
Well, I don't know. I presume she wrote it by her byline, and she quotes people. Most reporters only ascribe persons' names to quotes when they've talked to them. Our inability to deliver additional home shopping must-carry channels, in addition to the two already provided, did not, in our view, require a general notice to all subscribers. Our solution was to give a refund of the exact amount charged for the must-carry stations not received, $1.17 per month or portion of a month to each limited basic subscriber. That's where the portion of the month came in, and I think there was a reference in the earlier letter as well.
I'll find that as well.
So in essence, you're saying that if they were lacking a half a month of viewers or access to those free channels, they would only get refunded a half month fee for each channel that they did not receive.
I'm not sure
what they mean. Let me just go back to a letter dated October 15th, which Sac Cable wrote to Mr. Espasto. Mm-hmm. And on the second page, second paragraph, I think it's clear there that whether you miss the channels for a whole month or a part of a month, that they would be getting a refund for the full month.
That is clearer. The important point here is...
Well,
all right, that is clear.
I just want to establish that.
That is clear.
Okay.
The important point is that this is not properly charged under federal rate regulations.
I understand, but there was a willingness of Sac Cable and whoever the other companies are to refund that amount.
After it was collected, that's correct.
Okay, thank you. Thank you, Mr. Chair.
Okay. Anyone else want to bring forward questions or comments? All right. We've had an opportunity to hear the presentation from our attorney, Mr. Blair. Are there any actions that you desire to?
Mr. Chairman, I believe let's hear from.
We got some hearing.
Those.
Well, I didn't have a slip, so I couldn't hear from him. We'll begin with Mr. Ruker.
You're smart. You got some ice with
Good afternoon, Chairman and Commission. One, I would like to have an opportunity to have Darby come up and address the Rachel Thompson article. She, in turn, was the person that spoke to Rachel Thompson. The only comment that I can make in direction towards that is that, as you notice, there are no quotes in that article, and I will let Darby explain to you how the misinterpretation or whatever the direction that Ms. Thompson wrote. There are, from Sacramento Cable, as it has been identified, there are 3 letters. There is the letter of the 15th. There is the letter of the 21st.
Which months?
Of October. And there is the letter of November 3rd, which is today, which has been faxed, and it has been given by us as copies to you. Each one of these identifies as this entire process has kind of transposed itself and now transpired itself, and now we are sitting here with a situation of having to defend a lot of allegations. I would like to take this opportunity to kind of go through and bring you back to speed with why we had the traps in the field quickly, then go through the process of our decision-making process, which I do not agree with Mr. Blair, and then let you draw the conclusion and ask any questions that you may have. First of all, we did install traps back in 1991 for the purpose of making sure we could secure limited basic customers from being able to pirate signals above channel 27. The reason for that is because there's a lot of piracy and pirate boxes in the community, and since I took the scramblers off, the scrambled signals, and left them only on the premium services, by putting the trap on, it blocked every possibility of a illegal decoder or any type of scrambling mechanism to descramble our signals, because they would be unable to see it on a limited basic service, motivating a person that if they in turn wanted to steal service, not to take our lowest level of service, but have to take our highest level of service. And then we could watch that migration. That is the purpose of the trap. Back, it was not quite that clear. The must-carry laws changed, the retransmission laws changed, and we had all these new laws that were going into effect. On September 1st, the rates were rolled back. On October 1st, October 6th, we were to be completed with all retransmission negotiations and must-carry negotiations. I have kept you apprised all the way through that process, even have informed you as to how stations have either agreed, must-carried, or disagreed. On the last day, the retransmission day, we were able to, the last day of retransmission, October the 6th, we had struck our final deals with Channel 3 and other services just before the end of the period of time. During that period of time, as you know, the big concern was that what would happen if a channel were to be removed? There would be a vacant space there. If we could not reach an agreement with 3, 13, 50, well, not 58, but 40, then there was a chance that we would have to take them off the air at their request. To make a long story short, we were able to negotiate, reach an agreement, and on October 5th, we reached agreement with all TV stations, but not until October 5th. Now, it is true that we went through this process, and we did discuss the possibility of how we were going to detrap the system, and that did take place around the middle of August. There is a letter dated the middle of August where I am requesting from Channel 29 to have their permission or asking them to please send me another copy confirming their must-carry request, because in their letter they left it vague that they would be willing, and specifically willing, to take Channel 4. And if that were the case, and we were willing to negotiate for a lower position, 4, 10, 9, any other position under 27, we may not have had to remove those traps, because we would be able to negotiate and would be able to provide all the services down below that level. Excuse me, but could I have a glass of water? Sure. Thank you. We started the process. Thank you, Rich. Okay, and we'll give it a commercial. During that process, obviously we went through quite a bit of discussion. We were trying to get Channel 29 to accept a position less than Channel 29. We were unable to do that. Finally, on August 13th, we made a decision, and the decision was that they would not accept a position now lower than Channel 29. We had offered them what is A-1. We offered them that somewhere between 12 and 13. We offered them 20. We offered them several other channels. They did not accept any of those channels. There were negotiations going back and forth. There were meetings with Mr. Gruber and Mr. Foster. We tried everything we could to resolve this issue so that Channel 29 could be carried under Channel 27. It is true that we finally said we give up, and we decided that we can't reach an agreement, so now the traps must come out. Approximately on August the 20th, right in that area, we started to have conversations of how we were going to remove these traps and how we were going to do it in an expeditious way. We actually started detrapping at that period of time. There has been allegations that we had to force appointments. That is absolutely false. These traps are located on the pole, they're in the pedestal, and we went out to the home and that we would remove those traps. There have been discussions that we didn't know where the traps were. That is false also. We knew exactly where the traps were. They're identified by the customer, by rate code, in our computer system, and not only could we identify the customer, but we could also identify their location. And furthermore, we established a way in which we were going to detrap the system. We went out there and we started to allocate 4 people into the process. That is accurate. The process took that evolution because, let's reflect a minute on timing. On August the 20th, we start to detrap the system. On September 1st, the new rates go into effect. If you go back and look at the telephone logs, you'll see that gradually starting in August with all the media and all the information, the phones started acting up, and when people found out that they could start to get additional outlets for free on a monthly basis with no monthly charge, which is a savings of $7, and that they could get a box and get that for a $2 and some odd cent change through all of our disclosures, the phone started to heat up. We thought that we could allocate all these people. Just to give you an example, I can't be specific on the exact dates, but back prior to August, we were doing approximately 80 additional outlet installations a day. Last month, we were averaging approximately 530 installations a day. And why did I make that decision? Because of several reasons. I could be fined for telephones. I could be fined for being out of compliance with installations. I could be fined for not doing my disconnects on time. I have all these issues that I had to take into consideration. I couldn't let down all the other things and at the same time throw a whole bunch of people into the process to detrap the system. So when it was slower, we gave more people. As it got more complicated and more busy because of more work, I had to throw more people into the installation and service, to the point that many of my pole technicians were having to run service, and service was having to run installations, and so on and so forth. We've been through the process of how we dealt with some of these problems. We went to our contractors. We asked them for more information, more bodies, more people. We didn't hold back. Our expenditures went through the roof to try and comply with all of these issues. Just in notifications alone, in excess of $500 total $1,000 in notification process. My labor costs went through the roof by hundreds of thousands of dollars. But we were going to take whatever we could do to get it done. Why are we able to escalate the process? The process is possible to be escalated because the phone volume is now starting to gradually come back. The amount of calls are starting to reduce. The amount of new additional outlets that are having to be added into customers' homes are coming down. You know, and we look at some things and we say, how about the process of this issue about not refunding credits, giving back credits, the $1.17 portions of the month, and so on and so forth? Or what did we do prior to that when a customer downgraded their service from full basic to limited basic? We didn't go out and put a trap on their pole. We gave them free service at full basic rate until we could scramble the signal on October the 1st. So the reverse was true. It was the exact same thing. When a trap couldn't be taken out, we were going to give them a full credit. And let me clarify that again and again. Maybe today's letter is not as clear as it should be then. The facts is that I am willing, and our company is willing, to give a full credit of $1.17 for all the channels and give it to them on a monthly basis, whether they are disconnected on the 2nd or the 28th, it doesn't matter. They will get a full month's credit, and they will get that credit until the trap is removed. So, in essence, if I go to your home today and I remove your trap on November 2nd, I think it is today, 4th, thank you, on November 4th, then you will receive a full credit in the month of November of $1.17. And in December, you will be charged $10.50. And that's what we mean. In my letter, both of the 15th and my letter of the 21st, the letter of the 15th identified a credit, the $1.17 credit. And we have been doing that and are doing that now. In that same discussion, we discussed the issue of Channel 29, and I haven't brought up KFCB. But KFCB was another issue. If you recall, on September the 10th, they went for a special hearing with the FCC, or tried to get a special ruling with the FCC, which forced us into having to carry them and didn't allow us to drop them. At that time, I had to file another disclosure, and I did, a full disclosure. By the date of the 15th, we had removed approximately 5,000 traps from the area, and we gave them a date of November 30th, thinking that we would be able to escalate this at a very, very high rate and get it done. Then I discussed the issue of the credit of $1.17, and we committed to doing that. Later, and this was basically done to create the foundation for our December 21st meeting. And that was the informal hearing, or informal process. And we were going to go through this process.
October 21st meeting.
On October 21st.
You said December 21st, I think you said.
Oh, I'm sorry. October the 21st. And we had a meeting with Brent Blair, Rich Esposito, Jack Fudge from Baker and Hostetler, my staff, and myself. The items that were discussed at that meeting were reflected, one, in the letter of October the 21st, but in recap, that we would refund $1.17 and give a credit for every month, for each month that the trap was on the customer's home. That we asked them at that time to extend the period of time from November 30th to October 28th. February 28th, excuse me. I'm looking at that and reading this. We agreed to print the bill, on the bill, a complete recognition of what the credit is about. And that was proposed by Rich Esposito. some sort of disclosure. I said, well, how about instead of a full disclosure, a 70,000 mailing to all of these people and discussing all these rates and all the channel changes again, why could we not just print on the bills of only those customers that are affected by it, that they would be receiving a credit of $1.17? We thought he agreed to that. The fourth point was that we would provide them a map at Mr. Blair's request, a map, and show how the manpower would be used to get this process done at that time by February the 28th. We were unable to, in our meeting, to walk away with anything other than a feeling that these 4 points and these proposals were acceptable to Rich, and that we could go forward and expect our actions to be received positively. We have had these processes before, and we have reached a very reasonable and suitable solution. And I want to say here today that our cable company is not interested in formal processes. We are not interested in litigation or arguing or fighting or any of this nature. We feel that this is a fair and equitable process, and we would like to work with Rich to try and accomplish this without a lot of hoopla. We feel it's fair to refund $1.17. That is what we're charging. We didn't go out there intentionally charging $10.50 and then wanting to run out there and give them a credit. We thought we could get the job done by the 1st of October when we were going to scramble the system. This is not an issue of scrambling. It is an issue of must-carry and retransmission consent. And we were not going to remove the traps until we were absolutely positive that those traps had to come out and that we had no hope of negotiations with these TV stations, which would have been Channel 64 out of Stockton, Channel 29 here in Sacramento. And of course, we already had our agreements with Home Shopping Club. We listened, we tried to negotiate, and we were unable to do it. Once we had determined that, we immediately started detrapping, and we thought we could get it done. And then when we saw the volume of calls, when we saw the volume of converter boxes that were being deployed, the unbelievable rate at which people were calling concerning their bill, even if they were going down, going up, whatever. And we pushed all the people that we had to the point that our average workforce hadn't been off for almost 5 weeks. And we did everything we thought in our power.
Can I ask one real question that puzzles me about that then? You said that the traps were installed in, was it 1991?
Mm-hmm.
Okay, you said you kept really good records, so you knew where all those traps were. So you knew who your subscribers were that had traps.
Yes.
Okay. If you knew where they were and you knew that you weren't going to be able to get to taking them out, why did you charge people?
I'm sorry?
Why did you charge?
Well, because we had to establish our new rate codes that we had.
That's fine, but you've got the charge, you've got the code, but you know who those people are now who are not getting the channels that you're charging for. So why didn't you, in your billing system, just not charge them for them?
Well,
you had an opportunity as a company to do that, did you not?
We could have done that.
And you decided not to.
Could we have gone in there and just identified these customers and said, okay, we're not going to trap these people. I mean, these people are
not going to charge them. They're not getting what we're charging them for, and so why are we charging them?
Well, I will tell you that I
don't even know if this is the only instance where you're charging for stuff that maybe you shouldn't be. And that's another issue for another hearing, perhaps. But I think you had a choice to make. and you made a choice that you knew. You say you had good records. You knew where those traps were. You had the choice of whether to charge for channels they weren't getting or not, and you chose to charge them.
Yes.
I mean, that...
We charged these customers because of the new rate regulations and to go in and to establish a new billing requirement. We could have gone in there, but it's not as simple as what you are kind of making it to believe, that you can just go in, enter in a number, and change only these people's rate codes and so on and so forth. It's not quite that simple.
It's simple enough, it seems to me, when you charge people when they want to add on a service, you immediately are able to follow, to get that on their bills.
That's absolutely true, because those rate codes are already established, and we don't have to create brand new rate codes. This would be a brand new rate code. We would have to go in and reestablish all the database and reconfigure the whole thing so that we could go through and not not bill some for certain rates, whereas when you're talking about HBO or additional outlet, those rate codes are in place all the time.
Well, that's true, but then it seems to me you also must have made a decision that you had a choice, too. I mean, the choice was that these people could have been getting signals higher than that. It was a choice to begin with to install the traps. It was a choice to charge them, to not go to make the investment, to charge them differently for channels they weren't getting. It seems to me that all along you had choices and you made conscious decisions.
We did have choices, and here was the choice that we elected to do. The new laws were going into effect, and imagine the confusion that customers would have had if you were to say that here is your disclosure statement, and it says, and all the publicity, that your limited basic customers are going to be $10.50 and your full basic customers are going to be $20 and some change. And now all of a sudden you get your bill and it's $9.18 or whatever it would be, removing that $1.17. The situation was that we would rather bill them and let them know what they're being charged and give them a credit back, and we then could give those credits back every single solitary month, and they could be adjusted at the end of every month. So you could take all the customers that are being billed on December the 1st.
Let me ask a question about that. I just want to know the intent. Did you then come to Rich or someone and say, look, we're overcharging these customers and so we're planning a credit system? Or were you notified by someone that you were overcharging?
I was notified by Rich that we were overcharging.
But you knew you were overcharging, it sounds to me like.
Pardon me?
It just sounds to me like you said you knew you were overcharging, but you didn't volunteer that information.
I'm saying to you that we were charging the rate that they would be paying as limited basic customers, and that we were issuing credits back to those customers as those months went by, whether they were on for the whole month or not on for the whole month. And we were going to refund and are refunding $1.17 for every single customer that has a trap on any portion of a given month.
But it sounds like someone had to jog you into doing that. That's what
Absolutely
it sounds like.
Not. That decision was made prior to the date that we were unable to get the traps out of the system, and that had to be determined on or around the middle of September, because October was when we were going to start scrambling. September 1, we had our new rates in place. We were already implementing the credit policy and the credit procedures and doing all these things and getting it ready so that we could credit the customers. Now, on October the 1st, I'm confused in my date, so let me get this straight. We waited until we got to the 1st of October. At that time, we realized that we had a lot of people here that are going to have to be dealt with, and we're not going to get the traps out. We knew that just prior. We were not going to be able to get it done by October 1st. So we then went into the process in September, started configuring the database to issue these credits. In the month of October, we issued the credits. We were processing it and getting it ready, and now in November, as early as last week, we started issuing all the credits for those people. At the same time, that's when we talked about with Rich in the informal hearing on the 21st that we would provide a bill printed informational insert, and that we would inform those customers at his recommendation that they would be receiving a credit. And we would provide our trap deployment. I think that we have done everything that we possibly can do. We are being fair, and as far as this isolated outage issue, it is not an isolated outage. And I wish today, and I know that many of the members of this commission will remember the comment made by Terry Castanis about heavy-handed. It was over this issue. He wanted to be able to hold a hammer over my head or our head because I may not be here, somebody won't do it, and we might not treat the customer fairly, and so these penalties would be used only in a case where we were trying to violate and hurt the customer. We were not trying to hurt any customer. I made no benefit out of this. I received their money for 30 days, and I refund their money the next day in the way of a credit, and every month they're out until their trap is removed. There is no financial gain. There was no box. And
why is it easier to do a credit than it is to set up a computer program that wouldn't have charged them to begin with? I mean,
I truly, I can laymanly give you an answer, but I truly cannot respond to that and be able to do that intelligently. But let me put it to you this way. A credit is a single rate code that is being issued and given to a certain class of people. For instance, in the case of limited basic customers, they're identified in several ways. They're identified by their rate and their level of service. You could identify those customers, and as they were starting to reduce, you could establish a rate code as a credit easier than you could go in there and start creating a whole new rate, which would be a rate of $10.50 less $1.17. It would be easier, and it would be more clear to the customer. A customer is going to get billed $10.50 when that trap is removed. That is the rate for limited basic. And if they did not receive the channels, getting their credit would seem to be satisfactory, and that they're getting billed the $10.50 and seeing a $1.17 credit. And I did not indicate that we felt that in the case of a credit we had to do a full disclosure. And then after talking with Rich, I saw no harm in what he was recommending, and that was to put an explanation on the bill, and only on the bill, of those customers that are limited basic and are affected by this. So we established it, and we did it. And I think it was a good idea.
Mr. Chair?
Yes.
Might I ask a question along this line? Thank you. So are you saying that there are representations from our commission staff that disclosure of the ability of the customer to receive a credit was sufficient?
No, I will tell you what I feel happened. As you recall, I went through the 4 points, and at the conclusion, we went to this meeting, we had this informal process, we discussed it, and my attorney, my staff, nor I felt that we heard anyone during that process or any time after that process say that was unacceptable.
But the informal process was not a final, that was a preliminary procedure to get to this stage. It's an option that's not necessarily directive of what is appropriate or inappropriate. Is that a final determination, that informal process?
My understanding is yes.
Okay. I'd like to hear from our counsel.
If I may, Madam Commissioner, I think that what Mr. Ruckert said in his letter today is a better reflection of what happened, to my recollection. He said, and this is in the second full paragraph on page 2, fourth sentence. Surely, Mr. Espasto, you will not have forgotten that your participation following the initial salutations was as a listener that provided no input, suggestion, or comment. And I will tell you that that was purposeful. Since we have no authority to waive your commission's regulations, we view this as an opportunity to obtain informal compliance. I asked non-pejorative questions of Mr. Ruckert, and until late in the conversation, no one spoke to Mr. Ruckert. It was not the purpose to express opinions or to argue or to do anything of that nature. Mr. Espasto did not suggest anything to indicate that he was satisfied with what Mr. Ruckert had proposed, and in fact, I asked Mr. Ruckert a variation of the question asked by Supervisor Collin. If you knew who these people were and you could find them to give them a credit, why did you charge them in the first instance? And at that point, after, from my perspective, being unable to formulate an answer, Mr. Fudge took over. But there was never an indication, and I'm trained to do this, so I didn't give any indication. Those determinations are for you alone to make.
What did Mr. Fudge say?
Mr. Fudge said that he did not feel that well, he's here and he can speak for himself, but my recollection...
I want to know what you heard him say.
What I heard him say was that he didn't feel that the isolated outage was intended to apply to this type of deprivation of channels, and therefore that the credits weren't appropriate. And that's what I heard him say.
Well, Mr. Blair or Mr. Espasto, was there any indication that you were not satisfied with what SAC Cable was presenting or proposing?
Well, I don't think there's any question of what a reasonable person listening to my questions and the incredulousness with which I asked that question would recognize that I personally was not satisfied. But you must keep in mind that I'd advised Mr. Espasto before the phone call. It was not our place to decide whether we were satisfied with that answer. It was our place to try to obtain informal compliance with your regulations, which Mr. Ruckert ruled out before the conversation got underway. There was to be no credit for service under the isolated outage. So it was not our place to express disapproval any more than it was our place to express approval. I saw Mr. Ruckert nodding a moment ago that I did not express any approval, nor did Mr. Espasto. Neither did we express disapproval. We're not in that position. It's not our. We're there to frame the decision for you. If we could get informally compliance with your regulations, then we wouldn't be here. We were unable to do that. We told Mr. Ruckert that we did not think that complied. We'd already told him about the credit. And Mr. Fudge and I had the interchange I've described for Supervisor Cox about whether or not the isolated outage credit applied. He did not think so. But it was not our purpose to argue the case, and that was not our attempt. We simply attempted to gain a clear determination as to the level of consciousness, whether or not there was a knowledgeable choice, and everything Mr. Ruckert said here, pretty much he said at that time, and that was the purpose of the conversation. When we determined that we had the facts and that there was not going to be compliance, we rang off the conversation.
You just mentioned that at that time you didn't think they were in conformance or compliant?
Absolutely not, yeah.
Why didn't you tell them that?
Mr. It's real simple. The issue before you is, were the customer service regulations violated? Mr. Ruckert started the conversation by saying, no, they hadn't been, and he wouldn't do a disclosure.
No, I'm talking about his proposal to rectify.
He refused to rectify that issue.
The rectification was inadequate. I don't want to use this pejorative. It's the only analogy I can think of.
Are you saying the credit is inadequate?
Absolutely. Yeah. If I rob a bank and I'm out on my way outside the bank with the money and a police officer stops me and he takes the money and gives it, I can't say I'll give the money back and absolve myself of the offense.
I'm not sure I can accept that kind of a
I understand the pejorative nature. I just can't think of a better one. I thought about bananas.
I don't think it's proper.
But, that's for you to decide. If you don't think it's proper, then you don't have to do anything in regard to this. But the point is, is that your regulations call for a credit, in my interpretation of those regulations. You don't have to require that credit for the customers. You can say simply giving back the money was good enough. However, we did have the very discussion that Supervisor Collin elicited herself here today with Mr. Ruckert. If you knew who they were and you were able to identify them and put in some kind of code to give them a credit, why did you charge them and take their money in the first instance and put it in your bank account and give it back to them after you heard from Mr. Esposito? And the answer is, there is no answer for that.
He gave an answer.
I gave an answer.
No, he didn't.
I did too.
In my mind, he did.
All right, well, you're the judges of the fact. If you're satisfied, that's all you have to do.
Mr. Chair?
And I'll be happy to clarify that again, is that it was far more complicated and far more difficult to give a separate new billing than it was to charge them their new rate code. The logic was there. It was what was best for the customer. You are sitting here changing all your rate codes, all your channel lineups, all these things are happening, and you're trying to get some sort of consistency in the billing, in the lineup, and everything. So you bill them at the $10.50 and you give them a credit back for the $1.17. The credit is easier to initiate than changing our entire billing system to accommodate a new rate code like that.
Let me tell you, Kim, what I find wrong with that.
Okay.
What I find wrong with that is I don't think there was ever a disclosure to the person when they got their $10.50 bill that they weren't getting the 3 channels and that you had any intention of ever giving them a credit. In fact, if they're not watching this hearing or they don't read about it in the paper, they're not even going to know. And the fact that you had to be notified, at least I understand that now, that you had to be notified by Rich about the overcharge before you even discussed this issue of them getting their money back.
Well,
I just tell you, I for one am ready to...
Let me also make a comment. My concern is this is a hearing to determine whether or not there's probable cause.
Right.
The question, the line of questions that are now beginning to emanate from this board indicates that a decision has already been made as to the guilt or innocence of the parties. And
the probable cause. I'd rather have it at a hearing officer, frankly.
Well, the remarks that are being made imply that there's a guilty party already, and the real question is whether or not there's probable cause. Mr. Chairman, we still have some other people that want to speak. If there's any questions of Mr. Rucker, we ought to ask those, but we ought not to make a determination as to whether or not he's guilty, that the firm is guilty or not at this time. The question is whether or not we're going to have...
It would be my assumption, Mr. Cox, that having asked Mr. Rucker to come to the podium, that the members of the commission would have the option of asking questions as they find them to arise in their mind. But if we want to close it off, we'll close it off.
You can't jump to the conclusion that they're either
I'm not jumping to conclusions about anything.
I understand.
I'm listening to everything that Mr. Blair had to say. I'm listening very much.
Questions that are emanating from this council at this time, though, are on the basis that there's a decision that's already been made.
The other speakers and let them merely offer their testimony, and we'll ask the members.
I don't know if I jumped on your question. Do you have any more questions?
I had a number of questions, but
Good. Go ahead.
I'll be a little more aggressive in asking them. It goes back to one of the questions I have of council. Is the objective of the informal compliance process to gather information to bring back to us to make that determination on the merits as to whether or not probable cause has occurred? And was it more of a fact-finding function and then to give some attempt on your part to provide some ceasing of what you thought to be initial non-compliance?
The regulations tell us what we're to try to do in this process.
In the informal compliance process.
In the informal resolution, Section 801 of your regulations. In the event that the company shall fail, refuse, or neglect to fully comply with the requirements of these regulations, the Commission's Executive Director shall, except in instances in which time is of the essence in obtaining the company's compliance, and or the Executive Director determines such efforts would be futile. Neither of those applied here. Attempt informal resolution and rectification of the company's non-compliance by informal meeting and or telephone conference between the company and Commission staff, which is what we we did. There was no meeting, there was telephone conference. Said informal resolution effort shall be initiated by the Executive Director's general statement of the alleged violations under investigation and the general nature of the evidence then known to the Executive Director. In this instance, because of the complexity of the matter, we did that in writing so that we spelled it all out and they had a chance to review it with counsel. Notwithstanding the foregoing, the nature and extent of evidence which may be presented by the Executive Director in any subsequent enforcement proceeding pursuant to Section 804 below shall not be limited or abridged by reason of the presentment or non-presentment or recitation or non-recitation of such evidence in the course of the informal resolution efforts. Then there's another section, which I won't read, which states your Commission's preference for cure. But again, it is an opportunity for the staff to lay all of this out, try to gain informally compliance, not negotiate. We have no authority to do that, and to implement your Commission's preference for cure. That's what we were trying to do.
Now, and then we are now here trying to make a determination as to whether or not probable cause even existed to cite noncompliance?
Here you're to determine probable cause to determine whether or not there'll be an enforcement hearing, either before a hearing officer or before yourselves.
So, in effect, some threshold determination of a violation we've made that determination by your going out and seeking compliance. Is that correct?
Well, no. The informal resolution, there are really 3 steps to an enforcement proceeding under this. We erred on the side of due process. The first is informal. The second is what we're doing here today. The third is an enforcement hearing with sworn witnesses and testimony and cross-examination, either before you or before a hearing officer. It's a 3-step process. And the reason was because we didn't want to have any question about anybody getting blindsided. So we've gone to extreme efforts. There's no requirement that we spell it out in the detail in writing that we did for the informal process. But what we're doing here is determining whether you want to go to step 3. And step 1 is informal, step 2 is probable cause, and step 3 is the hearing itself, and that's for you to decide.
Okay. Thank you.
Okay. Brett, you mean it could end today?
I'm sorry?
It could end today?
If you decide that there is insufficient evidence to establish probable cause, that is a reasonable suspicion, the test I gave you, then it ends.
Okay.
And if I may say, I would like us to try to resolve this process. I thought we did informally. I absolutely felt that way. I felt that way whether it's because there was not a negative response to what our solutions were. We went forward with these things. We had some already in process prior to that date. We listened to a recommendation of a bill requested bill message on the limited basic customers bills. We did that based on that recommendation, and as per Mr. Blair's request, we also showed him how we were going to deploy the detrapping of the system, and we provided that. And when we provided that, we thought that met that it would meet with his satisfaction and the Executive Director's satisfaction. We've done these things. We are escalating it, and I am happy to say that I believe, because we have been able to get additional contract labor in Northern California to help out, my Director of Operations is informing me that we very well may be able to still reach that November 30th date. And I'm going to go and do everything in my power. And I will tell you today that when we spoke back on that date, we had about 15,000 traps still in the field. And my last report from our Director of Operations was we have closed in closer to 10 or 11,000 now. And we are doing everything in our power. If I could have it done tomorrow, I would do it. I make no money. When I want to make money, I go out there and I charge a customer for 27, 28, 29 channels, whatever it is, and I receive $10.50. To give a credit is not my benefit. And if you want to know the truth, to credit and go through all the activity to go into a customer's account and bill them and then credit them and bill them and credit them is a very complicated and expensive process. Now, I make no money doing this.
I think on that note, if there are subscribers out there who do not want the trap removed, is that an option?
They do not want the trap removed. Oh, so they cannot receive.
That is not an option, because these are 2 of the 3 channels are must-carry channels.
I understand.
They must be made available on the lowest available tier. They absolutely must be made available, or they're violating the must-carry regulations.
So that is not an option.
That is not an option, but what to maybe answer another part of your question, it is an option that they have for channel 36 and for QVC, which are satellite delivered, and we do get requests for things like MTV and for shopping networks to have them trapped out.
There are those who don't want.
Okay. Any more questions?
One last one, Toby. One last point for me, Mr. Blair.
Yes, sir.
The settlement hearing, or the attempted settlement hearing, or whatever that was, when did the $500,000 or $600,000 penalty come to light? Was that before that hearing, during that hearing, or after that hearing?
We discussed the calculation of that isolated outage credit in that hearing. That was what Mr. Fudge and I disagreed about. If you look at the notice of October 7 that was given to them in writing, which Mr. Fudge had before him when we had our discussion, we had asserted that they needed to give a credit for 1 day's credit for each 4-hour period in that initial notice. They were well aware of our position from October 7, and they had been for 2 weeks prior to that hearing. In that discussion, by the time Mr. Fudge entered the conversation, the only thing, to my recollection, that he and I disagreed about, and I cut that off because I don't think that kind of argument is helpful, is that he took the position they absolutely would not make a credit to their subscribers. Since that, in my view, is what your regulations require, there was nothing we could resolve. We have no power to waive your regulations. You may do that, but we have no power to do that. So that was definitely the major subject of our discussion on the 21st.
So the major disagreement in terms of any penalty that would be involved if this were sent to a hearing officer is the difference in those subscribers receiving the $1.17 credit or something substantially more than that.
That's correct.
Okay.
That's correct. We did leave the door open. We made the allegation that you had the right to assert a penalty, but that's never been the subject of discussion. All of the discussions have been whether or not 14,000 subscribers in Sacramento get those credits or whether they don't. And we're not talking about the $1.17. We're talking about what your regulations require because they didn't deliver what they said they were going to. By the way, I don't want to make this harder than it seems, but there's a reason why they didn't offer another tier that had 24 channels. And the reason is because it would have been illegal to do so. They were required to put 2 of those. The third one, QVC, they could put on any tier. But 2 of them, what? HSN. They could put on any tier. But the 2 of them were must-carries. Federal law required them to put them on the basic tier. So they couldn't create a $9.33 tier. What they they made, if you believe the evidence, is that Mr. Ruckert said, we knew we could have done that. And another point he said, we did have choices, and here is the choice we elected to do. That's the key. If you find from the evidence that there's a reasonable basis for the suspicion that in early August or mid-August they made a decision not to remove those traps until after scrambling, then they have you have probable cause to believe they consciously violated your regulations. They chose to collect the money and then credit it back. There's not been a question asked yet as to whether there were any subscribers who were charged $10.50 and who did not receive a credit until after they received the notification from the commission. I would suggest to you that as a fair inference, since they send out bills every week, that there were a large number of such subscribers. The suggestion to you that it was intended that they would put a credit on all of those bills immediately just simply doesn't comport with what we understand from the conversation. The credits didn't begin to appear until the telephone conference was scheduled. By that time, money had been collected. Not a large amount of money, a small amount of money from a lot of people. But that money was collected and went into a bank account and later went back. That's what I was talking about, Mr. Yee, about forget the pejorative implication of a bank robbery, but the point is the money was separated for a dozen bananas, only 11 were delivered, and then when that that was brought to light, it was the cost of the 12th banana, if you will, was given back, and only then. And that's the problem with this. What we have is a conscious choice, business choice, maybe for good business reasons, that your regulations were designed to address.
If I may.
Yes, you may.
I've gone from bananas to bank robbers and things like this, but I have to tell you that, first of all, the evidence is there and the facts are there. I started to take the traps out in August, and they came out. There was no intent to wait till descrambling. We started the process.
That wasn't the point. The point was, did the credits show up on the bills before you got notification that you were overcharging?
If you don't know who you're crediting, you don't know.
You told me you knew who had traps.
There were many people that had already had their traps removed.
You didn't keep track of those that you removed?
I'm sorry?
You didn't keep track of where you were removing them?
Yes, because when they're removed, we have them identified in the computer system, and we unauthorize that identification. And when the trap came off, we were capable of issuing the credits. We started to issue the credits at the beginning of the next month. So we were sitting here going all the way through this process, and we had put in the process of how we were going to credit. At first, up until September, we thought we could get the traps out. We were optimistic. We were wrong. During the month of September, we established our plan. We established how we were going to do our credits, and we issued and got these things developed, and we wanted to go through the process of detrapping, and we knew we were going to give them all their credits, whether they were going to get half a month, they were going to get the full month. We made those decisions. We disclosed that in my letter in the middle of October. We had already identified and informed Mr. Espasto how we were going to issue these credits. And we did do that. And with the informal process, which I accept that I thought was a more negotiating type of situation, where I could say, look, this is more practical, this makes more sense. Now I see where Mr. Blair is going to, but I have to tell you that this issue over this 12 channels or greater, 12 persons or greater being an isolated outage, for those that were not here, the intention of that was not for this purpose. The intention was, Mr. Ruckert, you got a street of cable customers that are out, and if there are more than 12 of them out there, you may elect to not run a truck out there because you don't want to spend the money. You'd rather get them on Monday morning and leave them out all weekend. And we put that in there for that very purpose. That is what an isolated outage is. And it was also defined as one channel or all channel, or more than one channel. And that was because we wanted to make sure that if a customer lost a channel, and that same channel was lost by more than 12 people on that street, that we would go out and fix it, even if it was one channel or 50 channels. That was the intent. And if we were to say to our customer, and that's where Terry Castanis said, I want to keep the hammer over his head, because I want to make sure that when he does this, he is going to act. And if he doesn't, it's going to hurt. And the hurt is, and in all reasonableness, please understand, 6 days of credit for 1 day? That's in essence what it comes out. For every 4 hours of outage, 1 day's credit. For 1 day, it's 6 days of credit. I'm going to get going. But this is an unusual circumstance here. I did not create must-carry. The federal government did. And if I wanted to and had to, I could have negotiated longer and longer, possibly. But I felt we were at an impasse, and that was the best. And whether it was on July the 2nd, July the 19th, August the 20th, it didn't really matter. The law, by the way, went into effect for must-carry of home shopping networks. There was misinformation given here today. It was on July the 19th that the federal government ruled that must-carry for home shopping networks was allowed. So this was not even an issue being considered, and Mr. Briggs and Channel 64 in Stockton were never even a part of the original channel realignment configuration. I also would like to correct that if I would like to, I could have created many tiers. And I could have created a tier for what, I don't know the exact amount of money, but if I wanted a broadcast tier of must-carry and retransmitted signals, I could have created a tier there inclusive of access channels. And then I could have created another tier of maybe only WGN, WOR, a few shopping networks that are not must-carry. I could have done that. No, it's not right. What was right was what we did, and it was the best decision. And that's why we did it, from both a business decision and what we felt was best for the customer. Bill them the full amount of money, let them pay it, and credit them back, and then when their bill comes back, they're not going to be overly confused. I thought that that was the more logical way of going about it. I still do.
Very good. We move on now to the next party. Thank you. Mr. Graber. Mr. Graber is next. Is he here?
Gruber?
Gruber, I beg your pardon.
I didn't think there was Graber around.
Gruber. You know what? Darby's come up next, all right?
Thank you. Well, a reporter's responsibility is pretty awesome, and that's something I realized for lots and lots of years being part of that respected profession myself. Something false can be said, and it can be used as truth of evidence in a situation such as this. Mr. Blair is right. Someone here is right, and someone is wrong. Kim Ruckert is right. Rachel Thompson is wrong. When I read that in multi-channel news, I almost fell through the floor. I immediately sat down and I wrote a very lengthy letter to Ms. Thompson expressing my great displeasure at her interpretation of our conversation. You will notice in the article that Mr. Blair was quoting, there are no quotation marks around what she purportedly says I claimed. This is a paraphrasing according to her own understanding of our conversation. I did notice when we were speaking over the telephone that she was in a hurry. She was not real interested in listening to me. I believe it was a job that she didn't really want to take on. It was something at the last minute and not very important. Well, it turns out that it is very important, and I'm quite distressed that she would use information like that and say something that I absolutely did not say. I know that we knew where our traps were. I knew that we were in the process of getting those traps off, that we had already discussed the issue of getting customers back their refunds so that we could be fair. Our whole aim is to make our customers happy and to keep the many people who work for us happy, and that's an important link. If our customers are not happy, our people are not happy, and that's we always strive for that kind of a partnership. After writing the letter to her, we chose not to write the letter because having been inside the industry myself, I guess I was particularly irate, and I said, okay, I'm going to take it on the chin. All of you have probably had the same kind of experience. And I said the only thing that's going to happen is I'm no longer talking to the national media at all. I'm going to stick with the proven integrity of our own local reporters who appear to take their jobs a whole lot more seriously than someone sitting in New York.
So you didn't send the letter?
No, I did not send the letter.
So she doesn't know that
we have spoken with her briefly over the telephone, but that's it. Okay. She realizes that I disagree and that I deny ever saying that. And I, of course, did not say that because it is not the truth. Thank you.
Okay. Next person is Tom Foster. Okay. Anyone else? Jack.
Excuse my handwriting, that's fudge.
Well, it looks like fudge now.
And if you're in Japan, it's Fuji.
No,
but here in Sacramento, it's just plain old fudge.
Okay, well, welcome, Mr. Fudge.
My comments this afternoon, and this will surprise you coming from a lawyer, will be very short, very truncated.
That's a real surprise.
Thank you very much.
Could you identify your relationship with the players in this hearing?
Pardon me?
What's your relationship?
I am an attorney for the Sacramento Cable Television.
Got it.
I'm sorry, sometimes we tend to be pompous and think everyone knows what we do, but that's what I am, and that's why I'm here. I only want to comment on some comments that have been made with respect to the informal resolution, and this is paragraph 801 of the customer service regulations as amended. And I want to do that because in my judgment, of all of the provisions which you have in your customer service regulations, this without question is the most important. I have these gray hairs because I've been trying lawsuits for 30 years or more than I want to remember. And let me assure you of one thing.
We have gray hair because we've been in so many of them.
No, I used to have very black hair. And that is that the political process is so far superior to the confrontational litigation that it's not even close. We see all of our courts in recognition of that seeking ways to avoid the cost and expense of this devastating litigation and go on. Here in your rules and regulations is a provision which, the title of which gives you clear insight as to why it is there. It says, informal resolution. Now, I'm an attorney and I know what that means. And it means, as the language says in clear and explicit terms, that there shall be an attempt at informal resolution and rectification. And anyone who has read this, and I read it before we went into the hearing, had in mind that that process was to come up with a practical solution. Not only is such resolution in this day and age a necessity in any type of dispute, but ladies and gentlemen, we are talking about an administrative agency that has an ongoing relationship, both for different reasons, trying to accomplish the same purpose, and that is to the provision of quality service to the customers. My client does not make money if he doesn't provide that service. He's in business to make money, and he does so by providing a good quality service. This commission has the job of overseeing that he does that properly, but that, ladies and gentlemen, is best accomplished by a cooperative effort. The confrontational and positioning that I have heard here today is fairly unique in my 30-odd years of litigation in this area, and I have appeared before many of the administrative agencies. Something has to be done for the benefit of the cable subscribers in this community to get these two parties working cooperatively together so that the energies can be directed towards providing that good service and not spending a lot of time and effort trying to draw fine distinctions. The other comment that I would make to you is that, as I said during the course of the informal hearing and meeting, and by the way, that was devoted primarily to a series of questions that was asked by counsel. He's very accomplished counsel. My reaction to it was not to object except in one instance to one question. Otherwise, I said to myself, and I had said going into that, this is an effort to try to informally resolve, and you accomplish that by being forthcoming and candid and laying it all on the table and answering every question that is put to you. And I am here to tell you that, with the exception of the one question that I thought was inappropriate and therefore objected to, Mr. Rucker answered every single question that was put to him. I came away myself with the impression that a lot had been accomplished, far more than I see or hear now. I guess my final comment was, because the other thing that I did comment on during the hearing was that You know, I spend a good deal of time in the litigation, the type of litigation I'm involved in, doing interpretations of statutes and legislative intent and what do the words mean. And I'm looking at an attempt to, as my partner once said, this is not a horse of a different color, this is a giraffe. This does not fit. This is not an outage. Outage, you have to have something. You have to have the light bulb in before it goes out. If the light bulb has never gone in, it's a failure to supply. And we are talking absolutely and without doubt about a must-carry requirement. If the federal government had not adopted regulations under the 1992 Cable Act, we would not be here today talking to you. And if they had not, on July 19th, contrary to anyone who was following the progress of the hearings with respect to the FCC, determined, for what reason I know not, that home shopping was entitled to must carry, we wouldn't be here talking to you.
We would probably join you in trying to get rid of home shoppings as must carries. It sounds ridiculous, but I must tell you that if this section doesn't apply, then I would say you've got almost a fraud situation in terms of telling people that they're going to have to pay for channels they can't get, they can't receive, because you as a company did not go out and remove the traps before you started charging them for channels they can't get. Whether they like those channels or not is immaterial. They're being charged for them.
I wish that we lived in the perfect world, so all of the plans of mice and men could come out exactly as you would hope.
No, but I tell you, I just wouldn't charge.
Excuse me, there are a tremendous amount of things that had to be accomplished, you would hope.
No, but I tell you, I just wouldn't charge.
Excuse me, there are a tremendous amount of things that had to be accomplished and which came boring in at one session, and that which was feasible one day was not feasible the next. But do understand that the subject of must carry and what happens when there is no carry, and the subject of channel positioning and failure to position channels is not something that has gone unregulated or for which there is no provision. It just so happens there are no provisions in your regulations because it's not something that your regulations require. There is provision in the federal regulation and provision for petitions by anyone claiming must carry status, either because of a failure to carry or not obtaining the proper positioning. And I submit to you, and the reason for my statement to council was being familiar with those regulations and the fact that that aspect of it was not something which was, as to which state licensing authorities were to concern themselves, but was kept at the agency level is the reason for my statement to him, plus the plain and practical meaning of language and what an outage is. Outage is after you've had it and you aren't receiving it. Outage doesn't occur if you've never gotten it.
I suppose if I were one of those must-carry stations, I would also be asking, how come you're charging people for a must-carry station that they can't get because you didn't go out and do something about them taking the traps off? Now, you can look at it from all sides.
I am going to resist the temptation to engage in the adversarial confrontation to answer a question that, in my judgment, with all due respect, has been answered 3 or 4 times. You may not accept Mr. Rupert's explanation, which I do, and I think is a very practical one, given the exigencies of the business and the options and choices that he did. What I'm looking at as a practical matter, is this a practical solution to a problem? Is this something which under paragraph 8, rational people should have come up with a solution? You know, we only have laws and we have a judicial system because someone in their wisdom thought that was better than going to the streets with clubs and beating on each other. I wonder sometimes if somebody didn't make a mistake in that regard. But in the recent trend has been to alternate dispute resolution. And central in your paper is an alternate dispute resolution informally. Get it done, save the cost and expense. Save the feelings, get something going. And I have said that to every company that I have represented, and there are a lot, most all of them subject to some form of state, federal regulation. Stop beating your chest, stick out your hand, get together and work with a solution and learn to live together and comply with the regulations. Make the political compromises, because that's what has to be done. It has to be done here. It should be done here. It should have been done in this instance. And I suggest to you that a determination under these facts to go back to accomplish that, if it hasn't been, is the proper solution, rather than stretching the facts to the breaking point under a distorted interpretation of regulations to get everyone so that they can square up and engage in the acrimony, engage in the accusation, the verbiage of the ill-gotten gains. That is not the cooperative type of spirit and effort that will eventually inure to the benefit of the customers who we are both trying to serve.
Question to Mr. Fudge. When did your telephone conversation occur? What time of the day on October the 21st?
Well, I know exactly, because I was in my office in Los Angeles. It was supposed to be at 9 o'clock, and the freeways wouldn't let me do that, and we delayed it 1 hour, and my recollection is it was 10 o'clock.
And you spoke for how long?
Close to an hour.
11 o'clock. Thank you, sir. I have a question of counsel, if I may. You then, you were with Mr. Espasto during that time, and you then made a decision to do what?
We were in my office speaking on a speakerphone, and we concluded by looking at each other early in the conversation when Mr. Ruckert ruled out any possible compliance with the credit, that we really had no ability to achieve compliance informally, that we'd been unsuccessful.
So that,
at that point, the determination to be made was whether or not Mr. Espasto wished to make the probable cause determination in his own right, or whether he wished to bring the probable cause determination to the commission to make. This is the step 2 determination, and we discussed it, and we discussed, because of the reluctance in the recent past to follow staff recommendations, we would kick this one to the commission and let the commission decide whether it wished to go beyond step 2.
Did you consult with any of members of the commission?
No, I did not.
Did Mr. Espasto consult with any members of the commission?
Did not.
Didn't have a conversation with a single person?
Not at that time, no.
And again, it would not...
Let's have a point of clarification. You and I met and discussed this process at length one morning at breakfast.
But I'd already made the determination that I would not make the probable cause determination. So there's one more factor that Brent mentioned besides some of the complexities. Because of the issue of the size of the refund, I felt that deservedly belonged on your lap.
When did you calculate the refund?
Probably that day or before.
In drafting the letter, probably the next day.
I'm asking Mr. Espasto.
I'm sorry. Go ahead.
We prepared the letter
and only as a matter of information, counsel, you can't represent both sides. You're representing the board. Okay, it's true. Thank you. My question is, when did you make the calculation?
I asked Mr. Blair if he would draft the notice, the letter, and in the course of that draft, either Friday afternoon or Monday, we inserted an amount into the draft. I would guess Friday afternoon, the 22nd.
You asked him on the 22nd to do the draft?
No, I asked him after the conference call. Mm-hmm. I made a decision, reviewing what was there, that I would not make the probable cause determination. I asked Brent to prepare the notice, and that notice was drafted Thursday night and Friday morning. Somewhere in there, we plugged in the number. We calculated the estimate of whatever it was at the time.
Okay, thank you. Thank you, sir.
Thank you. I was corrected. One statement is that while the must-carry for home shopping currently is in effect, that subject is being reconsidered right now by the FCC. Thank you very much, ladies and gentlemen.
Okay, at the end of those who wish to speak to the commission. That being the case, then we will hear what the pleasure of the commission is with reference to this matter.
Mr. Chairman, let me just say to you that I think today is a classic illustration of a problem that is reasonably apparent after having served on this board a relatively short period of time, and that is that there is a contentious attitude with respect to, I'm not saying it's just with the cable company or the cable regulators, but there is a contentious attitude here that we need to put to rest once and for all. It may very well be that there are changes that have to be made. I'll leave that decision to a different date. But I'm of the opinion, after listening to all of this testimony, that there is no probable cause for action. I believe that as regulators in an environment that an informal resolution calls for a good faith effort on the part of the regulators to say, in all fairness, that's not good enough. We would expect you to do that differently. And then in the final analysis, because of the magnitude of this particular problem, I believe that this should have been brought to this board to make a determination as to whether or not we wanted to proceed with a hard-nosed, heavy-handed approach, and that's precisely what this is. Now, I'm not going to sit here and tell you that I believe that there has been a best effort made by the cable company, but in all fairness, there appears to be a good faith effort. And the question then comes about as it relates to good faith is, could it be done any better? The answer is perhaps. Could it be done any worse? I guess the answer is that. It just seems to me that if in fact you have an organization that we're 2 months ago we were at loggerheads with Access Sacramento, and now we're at loggerheads with a cable provider. Sooner or later, we need to all recognize that the important consideration is that the only thing the customer wants when they turn that television on is to get that which they're paying for. Now, I recognize that if there were 3 channels that they weren't paying for, that the cable company ought not to, in fact, be able to charge for that. And maybe they ought to be paying some interest on the money during that period of time. I don't have any problem with those kinds of situations. But it just seems to me that sooner or later, we need to start working together. We continue to create these firestorms by our own actions. It's a classic illustration of continuing this kind of process creates a firestorm as it relates to cable providers. At the same time, boards sit around and tell people that we don't have enough cops out on the street, so we create an environment where the crooks come in and take advantage of the situation. You know, it doesn't make any sense to me. We need to begin a good faith effort to try to resolve these situations before they become problems, not after you have determined there is one.
Okay, could I respond and how I see it? And I respect Dave's feelings very much on this issue, and I have been on the Cable Commission for a long time. I feel that my first responsibility are to the people who are the constituents and consumers in this system, and therefore I would hold whoever the operator of the cable is to a very high sense of responsibility to those consumers. And maybe we don't like to be regulators, but we are the regulators. We are the only voice for the consumer that the consumer has, given even the limited powers that we have. We have in this community a de facto monopoly type situation where you have a company that I think will continue to make decisions. They will be business decisions to benefit the company and also to keep their subscribers. I don't have any problem with thinking that it's in good business in the long run to keep a good relationship going. But this Cable Commission didn't create the firestorm. I would love to have seen that if it had not been brought to the attention, how soon they would have been forthcoming. I'm still not convinced that they would have voluntarily started making the credits for what they were charging the consumers. That's about 14,000, 15,000 people out there at $1.17, whatever it is, a month more that they are taking in. They made a conscious decision to do that. They created the situation. Now, whether we have the correct process in place to how to solve that, the reason that the regulation that has been cited both by Brent and by the other lawyer is the fact that it was put in there to get their attention so that we did not continually have to act as a cable commission to continually be subjected to finding the little dollar or so here or dollar or so there that might be at risk with the consumers, that it would be in their interest to really make some business decisions that benefit both themselves and the consumer. And I just differ with you, Dave, as to, I don't differ with you as to the fact that it would be nice if there could be a really good working relationship between the commission and the cable company, but the real people that are getting left out of this conversation are the people who are buying the service from this company. And we're going to be called upon to make sure, in following both the Federal Cable Act and our own regulations, that we are protecting those consumers because they are in an almost monopoly situation. So I just differ with your conclusion.
Well, but are there any other comments or any type of motion to be made? Yes, Rich, go ahead.
Yeah, thank you. I'd like to make a comment first and then make a couple of the points that swayed or helped establish my opinion. As young as I look, my public service began in 1954, and it continues to this day. And I've never read in any government document or legal document, I've read the derogatory language that I've read in all of these reports that I've received in addressing this issue. Maybe it's a fact of life in this business, but it doesn't sit very well with me. My points, first and foremost, all of this problem was caused by external forces. In other words, the cable company did not decide one day, let's stir up a firestorm and we'll make a lot of profit out of the deal. This was caused by the laws that came upon us. Two, the logistics of what you had to accomplish. And I'll confess I hadn't thought of the point you made where you were between a rock and a hard place. If you concentrated solely on the removal of the blocks, then you're going to get held for not continuing to provide other service to customers. So there's another point. But the main thing I felt was this was caused by external forces, and the logistics of this are almost overwhelming, in my opinion. And I also agree with Mr. Cox that there's no cause for any action on our part.
Okay, anyone else wish to comment?
Yeah.
Jimmy?
Yeah, Mr. Chair. I try to look at this as to whether there has been good faith effort. And being a business person, I do recognize that there are situations where when you are confronted with a problem, you try to resolve it. But given the many problems that existed above and beyond just this overcharge, quote unquote, that we have to be understanding of the time element that's required to rectify the problem. I don't know that there has been sufficient evidence to the fact that there was some intent to commit fraud and overcharge the customers. And to that extent, I certainly, after hearing everything I heard today, that I do not believe there is enough information to determine that there was probable cause to continue any further. And to close it off, I certainly respect each member on this commission, and this is a perfect example of the term where reasonable people can have reasonable differences.
Okay. Anyone else wish to comment? Not. I only have one comment, and that is that I sat here today, as I have over the past 15 years, or is that long, Isla?
Whenever we had cable.
Listening to many presentations about litigation and the problems that arise when there is noncompliance with the regulation or when there are certain discrepancies with reference to the way in which the company that's charged with certain obligations as far as carrying out business for the people of Sacramento County. I don't have a great number of sources to go to. I have to go to the attorneys that advise us. I felt there was a very strong statement made by Mr. Blair, and I may have overread it, that we should get either to a hearing officer or this commission should sit and debate and deliberate in greater detail. I've heard Mr. Rucker, and I think he made some very strong and pertinent points today. I also heard Mr. Fudge as he gave forth in his general understanding of the best way to proceed with this. I don't really think that we're going to at any point say that everything we've heard is corroborated by fact and data that's been provided to us. I think we heard a lot of emotional statements along with the facts that were available to the parties that spoke. And I know there's a small amount of money, but on the other hand, Isla stated it earlier, we do represent a constituency that I feel responsible to, and I want to have better clarification and understanding as to whether or not there has been a violation of regulations, either by chance or by intent. And I think we can do that if the members are willing to listen to it. If they don't want to listen, we can refer it to a hearing officer. In either case, I think that the matter is aired and that we go on from there. I would hope with a reestablishment, if there is a breach in our relationships between company and government, get it back to a normal pitch. We always will be in the position, as long as we become the spokespersons for the community, to make interpretations of regulations. If we don't need these regulations, we would throw them out. But if we do have them, then we should be willing to abide by them and try to protect the customer. Do you have any comments? The two parties that haven't spoken.
Actually, yes, I do. I think that our role here is to either make the determination that there's probable cause, and that probable cause to determine whether there's been a violation. I don't think anyone that's asking for a hearing, whether it be by a hearing officer before this body, is saying that there in fact has been an ultimate violation, or but rather that there's sufficient evidence in the record and elsewhere and in the testimony that warrants a review. And I have no strong feelings either way, since as an alternate, I probably won't have the opportunity to participate in the hearing. But I do feel strongly that there's enough of discrepancies in the record that it does deserve a hearing, and I would ask for that and support that by way of a motion.
That is a motion, then.
That is a motion.
Okay, we have a motion. Motion and a second.
And that's a question. I have a question. You referring to a hearing in front of this body, or?
Well, I think staff recommendation is that it go out to a hearing officer. I don't have strong feelings either way. As I mentioned, I would love that I think that it's the role of this body to make that determination with direction of council. But if a hearing officer is the desire of the majority of the members that will be able to participate in that and have to come back to this body, then I don't have any strong feelings either way on that.
But your motion, to speak to your motion,
in fact that we should go forward.
We hear it here.
Yeah, I will propose that.
All right.
Do you have any other comments?
No. Bifurcate the motion.
I would prefer the hearing officer, just because I think there's been so much contact, but
okay.
away from a formal process.
Mr. Chairman, ask the motion to be bifurcated.
Okay, the request to bifurcate, does the maker of the motion have any problem with having first a motion to the matter of a hearing, and then secondly to make a determination as to whether it be by a hearing officer or by the commission?
The bifurcation would be acceptable to me.
Okay.
It's fine.
Agreeable. Okay, the motion initially is to the point of whether or not we shall have the motion is to have a hearing to determine the actual final opinion of this commission on the matter. And with that, please call the roll. Is that stating it well enough?
Panay?
Aye.
Collin?
Yes.
Cox?
Nay.
Pratt?
No.
Ortiz?
Yes.
Yee?
No.
Toby Johnson?
Yes.
Motion carries.
Okay, the second motion then would be, or second portion of the motion would be the matter of whether or not the matter will be heard by a hearing officer. Mr. Ortiz, you recommended that it be a commission hearing?
Actually, yes,
Okay, so
for
we'll
this
vote.
body.
We'll vote first.
I would like to.
Mr. Chairman, I wonder if we couldn't, Ms. Ortiz will not be here during this. I wonder if the regular person, Mr. Castanis, could participate in that decision.
All members of the commission, I understand.
Well, as an alternate, I have the full ability to vote on a motion here today. I don't think that I should defer or not propose a motion in light of Mr. Castanis' inability to be here today, nor any other alternate that may, or appointee that is not here today.
And quite frankly, we're not sure that Mr. Castanis won't be here the next time as well. That's hard to say, or that I won't be here, or that Mr. Yee won't be here. But on the motion itself, Mr. Chair, I think the commission should hear the item. I don't believe it should go out to a hearing commissioner. I think we should hear it. We should hear all the evidence and the testimony and make a decision on it at that point.
And that would be with the understanding that as long as a quorum are present, we could proceed ahead with the hearing.
Mm-hmm.
Question?
Yes, Rich.
What are we going to hear in the future that we haven't heard today?
You'll have cross-examinations.
You'll also have sworn testimony.
Sworn, all right, okay.
Yeah. But you should keep in mind, we got to this, I don't remember what the issue was a couple of years ago when we had one of these scheduled, and I know everyone who was on the commission then was shocked to find out they were expected to be there for an all-day session. Once you begin this, you have to give a full hearing to the other side, which means you have to hear any witnesses they want to present, and it may take more than one session.
Well,
nothing wrong with that, but
the entire hearing is legally recorded, as I recall.
That is true. It would be recorded.
So we do have the benefit, if we want to hear all of the testimony, then to take a period of time before we make a final decision, isn't it?
Certainly. Certainly. I was going to the issue that you need to know that you need to set aside a block of time if you're going to do this yourselves.
Sure. Okay.
So what's the motion?
The motion then is to have a hearing before this commission, and whoever happens to be in attendance on that particular day would be the party to make the decision, whether it be the alternate or appointee, right?
Yeah.
Okay. Well, please call the roll for a vote.
Panay?
Aye.
Collin?
No.
Cox?
No.
Pratt?
No?
Ortiz?
Aye.
Yee?
Clarification. If I vote yes, if this body will hear it. If I vote no, what happens?
Goes to hearing.
Another motion, James.
Oh, another motion?
Or just let it stand until the next time.
All right. No?
Toby Johnson?
Yes.
Motion fails.
Okay.
I would move that we utilize the offices of a hearing officer.
Okay, the motion, do I have a second?
Mm-hmm.
Well, I think this matter needs to be attended to, and I will second the motion. So the motion is to have it presented to a hearing officer for a decision.
Thank you. Panay?
Aye.
Collin?
Yes.
Cox?
Nay.
Pratt?
No?
Ortiz?
Yes.
Yee?
No?
Toby Johnson?
Yes.
Motion carries.
Motion carries. The matter will be further reviewed, but under the auspices of a hearing conducted by a hearing officer.
May I ask how the hearing officer is going to be selected?
We can ask the attorney.
There's a procedure spelled out in your regulation. We begin by exchanging lists within 10 days of parties. Each party gets to strike from the other list and so forth.
Mr. Chairman, may I ask one further? The hearing officer's decision, is that a final decision?
No. The hearing officer makes a recommendation. He comes back to you with findings of fact, conclusions of law, very similar to what you're used to seeing in a civil service setting. You may do any of those things. You may accept, you may modify, and then accept, you may reject, or you may send it back to the hearing officer for further evidence on some subject. Those are
in the event there's a rejection, and that closes the matter.
That's the end of the matter. Or you can enter your own decision, or you can just end the matter at that point.
Okay.
Mr. Chairman, I wonder if at the next meeting we could have, and it can wait until I'd like to have an executive session to discuss personnel, and then I'd like to put on the agenda the opportunity to discuss legal counsel.
That'd be agreeable with me. That anybody wish to voice an objection to have a legal session. All right.
You're
Executive
suggesting that
session
for the
goes.
next meeting?
Next meeting.
The next meeting is on the December what?
December 2nd, sir.
December 2.
December 2nd.
I'm going to be out of the country.
Thursday, December 2. You
better voice that.
But you're,
I already told him.
no, he's voiced it. Let me clarify for the commission. I had this question come up again last week, and this first time it come before me actually was whether a member of the commission is going to be absent if we should continue or delay to another date the matters that are on the commission agenda. It's been my understanding, and I may be in error, that all of you have commitments and obligations. It's very difficult to reschedule meetings. It's very difficult to take meetings other than on the day and time that we have regularly had meetings, which is Thursday at 2:30 in the afternoon. And I said, send your alternate, or if you don't have an alternate, then be absent. And if we don't have a quorum, items will not be heard. But if there is a quorum, I consider the ability and intelligence of the people that are on the commission to make decisions to be adequate to carry on the business of this commission, and I would like to have it continue in that pattern. Now, I don't know if there's a difference on that. If you do want to shuffle meetings and change, it's going to create problems not only for the community that anticipates our day of hearing, but also for members of the commission to hopefully be in attendance on a matter that they're interested in.
I agree, Mr. Chair.
I agree with the chair.
I agree.
Okay. Any discord? Thank you.